Hello, everyone. Welcome to Legal Funding Journal's Virtual Town Hall, Investor Perspectives. I'm your host, John Freund, Managing Editor of Legal Funding Journal. Thank you all for joining us. This is always one of our most requested and most enjoyed events of the year. We've got a terrific panel for you. So just going to have a few brief housekeeping items before we begin. All registrants will receive a link to a recording of this event, so please stay tuned for that via email post-event. The format of today's event is going to include a panel discussion followed by a Q&A with you, the attendees. So you can ask questions. You're encouraged to ask questions of the panelists. There's two ways to do that. One is by emailing me. You can submit emails to john@legalfundingjournal.com. The other way is on LinkedIn. You can use the comments feature there. We'll be monitoring that throughout the event. So I'll be checking both of those throughout the event. We'll get to as many questions, time permitting, at the end. And also, we'll be hosting virtual town halls on a monthly basis, addressing themes and topics that are important to our community. And we hope that you'll join us again at a future event. Lastly, Legal Funding Journal is the most comprehensive source of news and events taking place in the legal funding sector. Members rely on LFJ to stay on top of case developments, funding activities, regulatory updates, and people moves, as well as to gain access to original content produced by some of the leading thought leaders in the industry. For details on becoming a Legal Funding Journal member, please visit www.legalfundingjournal.com. With that, I'm going to introduce today's moderator, Ed Truant. Ed is the founder of Slingshot Capital, a capital advisory firm focused on investing in the global legal finance market, as well as other non-correlated alternative investment markets. He also serves in an advisory capacity as an operating partner with Northleaf Capital's private credit group. Ed is an advisory committee member of funds managed by Sage Capital Partners, a private equity firm focused on providing capital to the search fund industry. He is also a founder of Balmoral Wood Litigation Finance, a fund of funds in the commercial litigation finance market. Ed received a Bachelor of Commerce degree from the University of Toronto and is both a chartered professional accountant and chartered business evaluator. Ed, take it away.
Great, thanks, John. Let me first introduce our panelists. I'll start off with Joel Magerman. Joel has been CEO and managing partner at Bryant Park Capital since 2001. During the course of his career, he's been involved in closing approximately 200 transactions worth over $7 billion in value across a variety of industries. He's built a robust specialty finance practice at Bryant Park Capital with expertise in the litigation finance sector. BPC provides capital raising, mergers and acquisitions, and asset sale and or securitization advisory, helping clients reach successful outcomes in this growing industry. Next, we have Jamie Snyder. Jamie is managing director at Fortress Investment Group and the head of single case investing and research in the legal assets group. Mr. Snyder focuses on developing investment strategies relating to active and potential legal claims, and is responsible for overseeing the group's ongoing analysis of major litigation situations globally. Prior to joining Fortress, Mr. Snyder was a partner at Boy Schiller Flexner LLP, a litigation firm where he represented both plaintiffs and defendants in a wide variety of matters, including securities cases, shareholder derivative litigation, merger and acquisition litigation, and class action litigation. Up next, we have Chris Capitanelli. Chris is a partner in the finance group at Winston & Strawn, with an emphasis on esoteric structured finance. His experience involves a diverse range of asset classes with a focus on litigation finance, consumer finance, and fintech asset classes. Chris's clients include specialty finance companies, funds, asset managers, banks, placement agents, and rating agencies. And his practice involves a wide variety of financing transactions, including securitizations, private credit transactions, residual financings, and forward flow arrangements. Within the litigation finance space, he represents issuers, borrowers, lenders, and investors in consumer, mass tort, and single case commercial financings, including numerous transactions involving first-time borrowers and securitization issuers. And the final panelist is Joe Sippert. Joe is the founder, CEO, and chief investment officer at Kerberos Capital Management. Joe is responsible for ensuring the firm's adherence to its core investment philosophies, communicating closely with clients on products and strategies, and overseeing firm operations. Prior to founding Kerberos, Joe was a nationally recognized attorney, named to the Law Dragon 500, was repeatedly named a super lawyer and leading lawyer for litigation, class action, mass tort practice, and was listed in America's top 100 attorneys, and holds an AV preeminent rating by Martindale-Hubbell, the highest possible peer review rating. So with that, let's turn our attention to the discussion. I will first start off recognizing that we have a panelist with a variety of different intersections with the legal finance industry. And so maybe I can ask each of the panelists to just very, very briefly touch on how they and their firms intersect with litigation finance, whether that's commercial, personal injury, mass tort, what have you. So maybe Chris, I'll have you start off that discussion.
Sure, I'd be happy to. Hi, everyone. So our firm historically, I mean, at least my start in the litigation finance space was on the consumer side. And that's been, for the majority of the last several years, been kind of the brunt of our experience. More recently, over the past couple of years, we've had experience in the mass tort sector and single case commercial claims as well as some law firm funding. So that's generally our exposure to the market there.
Great. Joel, can you pick it up from there?
Yeah, sure. Thanks, Ed. Yeah, our firm has represented firms in almost sort of every sleeve on the consumer side, whether it be pre-settlement, sort of structured settlements, law firm lending, and on the commercial side. And we've represented parties both on the financing and the M&A side. So have sort of been across the board.
Great. Thanks. Joe, do you want to take it from here?
Sure, yeah. So Kerberos Capital itself is an SEC registered alternative investment manager, but we're focused on private credit and credit oriented products on the whole. Much of what we do is in the litigation finance or legal assets asset class. And so we have that same general credit focus within this space as well. I would say within that bucket, a lot of what we do is law firm lending. We do a lot of stuff with counterparties who are operating companies, but some legal assets at the core of the investment thesis, sometimes with insurance, sometimes without. Much of our stuff is mass torts focused, PI class actions, but we also have an opportunistic sliver in our fund. And so, we like to look at all interesting transactions across the spectrum.
Great, thanks. Jamie?
So Fortress's legal assets group sits within the credit group at Fortress, and we loan money to law firms. We make loans to corporations against broad portfolios of legal claims they might have. And we also do invest in the single case arena, although that's a lesser part of our business. And we focus on the United States as well as Western Europe and Australia.
Great, thanks guys, appreciate that. So maybe to kick off, we'll look backward over the last 12 months, and maybe I can ask each of the panelists to just comment on one item that piqued their interest about the litigation finance community, whether that's a case, a piece of regulation, an outcome, investor sentiment, that type of thing. Chris, do you want to kick us off there?
Yeah, sure. I'll lean into my position as the stated lawyer on the panel. Everyone else says, even though there are a couple other attorneys on this panel as well, but and focus on some of the new regulations, because I think it's been an interesting year with a number of new state and federal bills, some which have been passed, some which are still kind of making their way through the process, but mostly affecting disclosure, right, which has been kind of a hot button topic for a number of years now. But I think over this past year, kind of the heat's been cranked up on it a little bit with some new state laws in West Virginia, Louisiana, and Indiana, as well as Representative Ice's bill in the House, the Litigation Transparency Act, and the announcement of a new subcommittee to look into disclosure and potential disclosure requirements as well. So I think it's been an interesting year in that respect to see that conversation, which had been percolating and been in the sort of battleground, so to speak, over the past couple of years, really come to the forefront and start moving towards a head.
Great. Joel, what piqued your interest this year, past year?
Yeah, I would say for us, what's been interesting coming out of COVID is a lot of the leading funding sources across sort of all the areas are sort of maturing and sort of expanding their horizons from a standpoint of both capital sources and where they get capital. So how do I get access to capital? How do I create liquidity? like you'll see, like you've seen in other specialty finance areas, they're starting to thinking about that in a broader way, as well as sort of formally contemplating, how do they grow their business outside of an area they may be in, where commercial folks have been traditionally focused there. How do I look at other sort of sleeves under litigation finance? And the same with the larger consumer guys. How do I look at expanding into maybe mass torts or class action or law firm lending? And I've seen that, the last 12 months, there's been sort of an increased interest in that. And I think it really is as these folks mature and look at how they continue to grow their business, it's a combination of expanding capital, right, which is their, their raw material. And at the same time, how do they look at growing the overall business and, participating in a broader litigation finance marketplace.
Great. Joe?
I think for me, one thing that I took particular interest in was the continued evolution of the insurance component to this asset class. On the one hand, there's been somewhat of a pullback on the judgment preservation insurance product, which has affected a number of transactions that we were progressing through diligence. But on the other hand, I've also noticed concurrently that there's been an increasing number of insurers coming into the space who have not previously been in the space and who are interested in writing, bespoke policies, and who are willing to be, very commercial in terms of figuring out how to solve for, some structural issues. And that's been great as a manager in the space, because it's allowed us to get exposure to transactions that otherwise just wouldn't really fit the buy box. And I also think that anytime that the insurance component continues to mature, that's a sign that the asset class as a whole is maturing. And so that, I think, inspires confidence.
Great. Jamie?
So the item that most piqued my interest last year was the U.S. Chamber of Commerce's vehement opposition to the Corporate Transparency Act, which would have required U.S. businesses to disclose beneficial ownership information, and the U.S. Chamber of Commerce's opposition to a proposed amendment to the Federal Rules of Appellate Procedure, which would have required organizations filing amicus briefs, like the U.S. Chamber of Commerce, to disclose certain donors. In both cases, the U.S. Chamber opposed these requirements on the grounds that even, these requirements would have applied to their members and to their own organization. They opposed them based on burden, cost, and privacy concerns. We rarely agree with the Chamber, but we agreed with them on all of these issues. And we think those same considerations apply with equal force to the various disclosure requirements they're pushing against litigation funders around the country.
That's great. Yeah, the one thing that sort of piqued my interest recently, perhaps spilling over into 2025, was a recent Georgia jury award, jury that awarded Monsanto claimant $2.1 billion for a single plaintiff in Roundup litigation in one of 177 lawsuits against Monsanto. What is your perspective on the health of the mass tort market and tort litigation in general? Jamie, do you want to field that one?
Well, I think nuclear verdicts get way more attention than they probably deserve. That verdict is going to end up getting reduced significantly because the punitive damages that were awarded were unconstitutionally excessive. I think it was a 30-to-1 ratio. I suspect that will just easily be reduced, and there will probably be very little attention associated with that reduction, even though that's a check that's already in place to try to prevent outsized judgments that aren't tied as much to compensatory damages. I expect Monsanto will also likely challenge the verdict on other grounds as well, which is its right to do. The fact is, there are a whole number of checks that are in place to ensure the integrity of our verdicts in the U.S. legal system, and it's already extraordinarily costly and difficult for a person that files a case who has to subject himself to discovery, prevail on motions to dismiss, prevail on motions for summary judgment, win various expert rulings related to the expert evidence. And even if a plaintiff does prevail, like this one has before a jury, they face all sorts of post-trial briefing remedies that could result in a reduction or setting aside the verdict, and then they face appeals. The fact is, I think corporate defendants have a lot of ways of protecting themselves if they choose to go to trial. or if they choose to litigate the case. And I think, oftentimes when people talk about the mass tort space, their disagreement really isn't with a specific case, but with the US Constitution itself, which protects the right to juries, even in civil litigation in this country. The fact is that there is a rich tradition in the United States that recognizes tort is essential to deterring wrongdoing and ensuring people are fairly compensated for the injuries that they sustain due to unsafe products or other situations. So, broadly speaking, we don't think in any systematic a way that reform is required, although I suspect around the margins there could be modest changes that might make sense.
Great. Any other commentary from the panelists, or should I move on to the next? Okay, well, let's shift our focus to investment capital in the sector. Pretium, a relative newcomer to the market, just announced a $500 million raise. At the same time, it's been rumored that Harvard Endowment, which has traditionally been a significant investor in the commercial litigation finance market, is no longer allocating capital. What is to the Litfin space? What is your sense of whether this industry continues to be in favor with investors, and what are some of the challenges? Joe, do you want to field that one?
Sure. Yeah. On the whole, I think the answer is yes. It continues to be in favor with investors, probably increasing favor with investors. From our own experience, we talk to LPs or new LPs quite frequently, where we are told that just recently that institution has internally decided that they are now greenlighting initiatives in litigation finance or doing a manager search. Whereas, for the past 3 or 4 years, they've held off and it's just kind of, been in the queue. So the fact that is happening seems to me that, investors are increasingly interested. Probably part of the reason for that is that, as the asset class on the whole matures, individual managers have longer track records. Maybe certain managers are on, their 3rd or 4th vintage. And there are realized results that can be put up and analyzed that give investors comfort. It's very hard to do that on day one, but when you're several years into it, or at this point longer for many people, it becomes a lot easier. And so I think we are seeing some of that. You asked what are some of the challenges. One of the inherent challenges, I think, to raising capital in the litigation finance asset class is that even just the term litigation finance itself is sort of shrouded in mystery. I mean, it's very unclear what that even means. And it turns out that it means many different things. The media on the whole, not including LFJ, obviously, but the media on the whole has not done us many favors in that regard, because they often use, the term litigation finance to mean one specific thing, oftentimes case finance, specific, equity type risk on a single case, when in fact, there are many of us who do all kinds of different things, law firm lending, the credit stuff, the, portfolio finance stuff with insurance, stuff without. I mean, there's all kinds of different slivers. And so the effect of that is that an LP or, factions within an LP may have a preconceived notion about what litigation finance is, which is completely wrong. And, they may have a preconceived notion of what a particular manager's strategy is. That's completely wrong. I also think that, litigation finance provokes an almost emotional reaction sometimes. It's often the case that, investments get shot down because someone on the IC says that they hate lawyers, or they got sued once, and so they hate lawyers, and so they want nothing to do with litigation finance. Just to take one example, right? And so whether that's fair or unfair is irrelevant. I think it is something that is a factor. And that doesn't help. But I'd like to think that on the whole, the good strategies and the good track records, will win the day in the end.
Great. Chris, what are you seeing on the consumer and mass tort side?
Yeah, no, so I mean, I kind of echo a lot of the same sentiments, right? I mean, I was just at a conference back in February and heard from multiple people and multiple clients that the topic that was on everyone's mind, that was being brought up to everyone, and what they wanted to talk about was litigation finance. And for some of these people were people that we hadn't previously seen in the space, or as Joel mentioned before, people that we had encountered mostly on the consumer space who were asking us, we're thinking about getting into commercial. We're trying to look into commercial cases. We're thinking about law firm lending, or even on the flip side, right? People that we had seen mostly as investors in the commercial side, or in kind of syndicated placements, being interested in new consumer deals and wanting to learn more about that, right? So I think the interest from investors and the capital is there, right? One of the challenges that we continue to see from people, and maybe not necessarily for every like across litigation finance as a whole, but in getting into different sleeves of litigation finance, is kind of they like the returns, they like the product in theory, but they might not necessarily understand it entirely, or they may not understand the nuances that can impact their return, the duration of the cases, some of the intricacies of settlement, appeal, the whole process, right? How the collections potentially get paid out of a settlement, right? Especially in kind of the large mass tort cases. So I think there's still a subset of investors who want to get involved, but it's about finding the right opportunity to bring them into the space so that they can kind of build up some confidence, so to speak, and some experience that will then allow them to get into other pockets.
Okay,
And if I could just weigh in a little bit there as well to echo what both Joe and Chris said, we're seeing significantly more interest. I mean, I think at any given time we probably have 3 or 4 litigation finance transactions we're active with. There's significant interest in it. It's an uncorrelated asset that everybody likes the nature of that. The yields are high. And I think if you look certainly on the consumer side, there's a significantly increased interest on the securitizations. The returns continue to get tighter. And there's a greater demand in the market for those assets. And I think you're seeing the same thing as people are sort of understanding how to manage the combination of duration expectations and how the underwriting on various sort of individual cases within those mass torts or class actions can be sort of thought through. So I think there are clearly complexities there, but I think there's an increasing appetite.
Right. Yeah. So just to pick up on that thought a little bit, when I've been raising money over the last number of years, I found that investors were very focused on a specific part of the market. Are you finding that that's changing over time now that they've had some level of knowledge and interest in a particular part of the market? Are they looking to expand their horizons and get into other parts of the market? Maybe Joe, you can comment on that, and we can then turn that over to Jamie.
Yeah, I think the short answer is yes. I have seen that happen to an extent, but the driver there is not necessarily just the fact that a particular investor has a certain risk reward profile in mind. It might also just be that the source of the capital within an institutional investor requires a certain risk reward profile, right? And so this is a very loaded topic, but like one of the challenges to raising capital in this asset class, harkening back to the last question, is that there are different buckets that this could fit in, right? Like, is it private credit and then special situations within that? Is it specialty finance? Is it sort of direct lending? Is it maybe for some people in the private equity bucket? I mean, I don't think that there's a right or wrong answer. The point is simply that different people think of that different ways, and depending on where they're suddenly you've got a 5% allocation to, niche opportunistic credit, for example, and then suddenly that bucket has some free capital. Well, that's great, except then you've got to find a strategy that actually matches that particular profile, right? So that to me has been more of a factor than anything else.
Great. Jamie, what do you think there?
Well, I mean, some of our investors invest just in our credit funds and get exposure to legal assets that way, and then others invest in our legal assets funds if they want, to focus on that specific uncorrelated strategy, as Joel said. I think for us, when we're designing our portfolio, single case investments are a part of it, although they tend to be a small part of our overall exposure for a few different reasons. The first is really that single case risk is binary, and since we invest out of credit funds, our focus really is on the preservation of principal, and we can mitigate the risk in a single case by focusing on particular types of cases where liability is already established, either because regulators have found wrongdoing on the part of the potential defendant already, or because the defendants have admitted liability, but it's still is still ultimately a binary risk. The second reason, single case investments are a part of our deals, or a part of our portfolio, but only a limited one, is that they're delayed draw. So there can be a long lag at times between the time we make the investment or commitment and the time the capital is actually put to work. And obviously our investors prefer to get money out the door, and they want to actually have it deployed, not just sit around having to manage the capital until it's called by us to put to work. And then the third reason really is that, unlike some of our other types of investing, single cases can resolve without having even utilized the full commitment. So that can be another negative for us as far as investing goes. That said, we really like single case investments when we find the right opportunities, because they offer greater returns than some of the other products that we use and have. And I expect that they'll always be, a part of our overall investing strategy.
Okay, great. There's been some discussion in the industry about the increase in number of mass torts claims and the duration of the existing claims. Perhaps you can comment on some of the dynamics in the U.S. mass tort market as regards new claims and timelines associated therewith, and then how well or poorly the U.S. justice system is equipped to deal with some of these larger volumes. Jamie, maybe I'll stick with you on that one, and then we'll turn over to Chris.
Sure. I mean, there has been an increase in mass tort claims over the last 10 years in the United States, but I do want to note that there's been a material decline recently. Just earlier this month, the Administrative Office of the U.S. Courts found that there was a 14% decrease in the number of pending cases in federal court over 2024, and that was driven in large part by the 3M earplug settlement. And then another report that came out this past week from the settlement masters in the Camp Lejeune litigation suggested a global deal could be reached by the end of the year. And if that's the case, you'll see another enormous number of claims being resolved, and it will stop showing up in the docket. So I don't think it's been a one-way path upwards. There has been an ebb and flow of the number of claims out there. And I suspect at the end of this year, we're going to have seen, assuming this Camp Lejeune settlement global deal happens, we'll see a massive decrease over the last couple of years, at least in the federal courts. So I think, in many cases, the courts have been very effective at resolving mass tort claims and managing these multi-district litigations. I think where we've seen more problematic situations from a duration perspective have been in cases where courts just haven't subjected the parties to schedules for discovery or expert work or bellwether trials. Those are really the harbingers of for resolution. And when courts aren't demanding of the parties and applying pressure to them in the form of actual, schedules that they hold everyone to, cases can drag on for much longer than otherwise.
Chris, anything to add there?
No, I think that really covered it. I think the system is equipped to handle it, right? I mean, we're dealing with rather complex cases, and we have a complex system which involves and is always going to involve a split between federal and state, right? And there's going to be certain claims that make their way into federal, certain claims that make their way into state, and that's always going to add an additional layer of complexity to the equation, right? The MDL, like our MDL system, can in theory run a mass tort in an effective manner, and some of the states now are adopting so-called mini MDLs and other statutes to try to kind of emulate that on a state level to kind of bring more organization and have more coordination both within the state, but also between different states and with the federal MDL case that might be happening at the same time, which can help reduce some of the overall burden, right? But as these torts get bigger and involve more plaintiffs, right, and potentially involve some state actors, the complexity we saw with some of the opioids litigation, the duration can be heightened, and what would be helpful in addition would be some more coordination, I think, between some of the state and federal courts to help kind of move these cases efficiently and also reduce some of the redundancies and additional burden, which then causes even more consternation.
Yeah, fair point. Yeah, so let's keep on this theme of sort of mass tort duration. The extension of mass tort timelines has caused many law firm borrowers to refinance and seek increasingly large credit facilities, with some suggesting that this is a sign of that perhaps law firms are over leveraged, maybe as evidenced by the recent Chapter 7 filing of Aiken Muir citing about 220 million loans outstanding. What are your thoughts on the financial health of the mass tort sector and what needs to happen to bring it back into balance if it's in fact out of balance? Joe, you want to comment on that?
Sure. Yeah. The short answer to your question is what needs to happen is realizations. I mean, there needs to be actual monetization, by which I mean not just theoretical settlements, but like actual cash in hand. Like the wire transfers need to come into the bank account. Once that starts to happen, I think a lot of people will breathe a sigh of relief, and things can move forward in a healthy way. One of the challenges to investing with mass torts as collateral is that it's almost inherently sort of like counterintuitive by traditional private credit standards, for example, right? So if you have a mass tort loan, the investment thesis could be, there's $100 million of collateral, and we're going to loan $20 million at a 20% interest rate, right? And we believe there's going to be a monetization in 3.5 years, right? So that could be your investment thesis, and it might be entirely correct, right? But notice what happens during that period of time. Like year 1, not a single penny comes in. Year 2, not a single penny comes in. Year 3, not a single penny comes in. So if you were to look at the loan, if you were reporting to your LPs, right, on the status of that loan, and you said, here's the status of this asset. The LTV is now, 70% basically, and not a single dollar has come in 3 years. A common sense reaction to that would be, this is the worst loan of all time, right? Like, what were you thinking when you did this loan? This is non-performing. And the answer is no, actually, it's just fine. Like, the collateral is seasoned quite nicely. The cases are moving along, and we are on target to get paid, tomorrow or next quarter or whatever. And, so long as that happens, then everything is fine. And, there's a sort of complexity premium that you're getting for a trade like that, which is why, the interest rate might be 20% plus or whatever it is in a particular deal, but it's not cheap. But that's part of the reason why. But you have to understand that going in, or else it's never going to make sense to you, right? So that's all fine and good. I think the problem that has happened and what we're now seeing is that some people just got the duration calculus wrong. I think both law firms and lenders underestimated duration. And so in my example, you're projecting a monetization after 3.5 years, and it turns out that instead of 3.5 years, it's 5.5. All right, well, you would think that that's a forgivable error, except no, actually, that's the difference between having your LTV be 65, 70% versus over 100, meaning you're underwater on your loan, and now you're writing down interest the longer that the loan continues to go out. And after 6 and 7 years, now you start to have real issues. So I think that there will be a period of religion here, where people realize, okay, we got a little too crazy and drunk with enthusiasm about really scaling our mass tort platforms and having advertising campaigns that saw no limit. But we forgot that we have to spend a bunch of money to keep that larger infrastructure going. And we forgot that these things might take 7 years, not 3 years. And those are lessons that will be learned, I think, by a lot of folks.
Yeah, absolutely. Jamie or Joel, any other commentary?
Yeah, I think the other thing I totally agree with what Joe said. I think duration, obviously represents a challenge. And I think the other thing is a lot of folks are realizing, our clients who are the funders who we're raising capital for, not all claims are created equal, right? Some are worth significantly more than other ones within a mass tort, and there are various things that are going on. And I think there've been a lot of lessons on both that piece and duration piece that I think sort of the next cycle of capital is going to account for. But once these settlements start coming in, I think the system will get a little more relaxed.
Yeah. Jamie, anything to add there?
Sure. I mean, I think we haven't seen the issues that you were describing in the question in terms of having borrowers who are over levered. I mean, we really try to avoid investing anywhere near the loan to value ratios that that Joe mentioned, and it's, you know, there have been some massive resolutions in the last few years in opioids and PFAS, and I mean, for that reason, I think we've actually had an issue where some borrowers are paying us off quicker than we would have liked. You know, we obviously try to protect against that in our loan documents, and we also try to have mechanics in there to address a situation in which duration is dragged out and still protect our returns. At the same time, we never want to be in a situation where a borrower is over levered just because the duration or timeline has dragged out a few extra years. That's obviously a huge risk in this industry. But ultimately, I don't think it's especially surprising that there are some irresponsible borrowers and that there are some either irresponsible or you know, maybe just ignorant lenders who've entered the space with unrealistic expectations about timelines or thinking or being overconfident that in resolutions within specific timeframes. Not sure that makes this industry different than any other. And for that reason, I'm not sure it's of any great consequence.
Okay, great. Just keeping on the duration theme, COVID is clearly in the rearview mirror, but are there effects of COVID still impacting the industry, either positively in terms of the courts embracing technology or negatively in terms of settlement delays? Joe, do you want to field that one?
Yeah, sure. I think that at the margins, probably the technology emergence, you know, the use of Zoom and things like that for courts has helped progress things. I don't think it's been a huge material impact. It's probably just largely, you know, save people, you know, a trip to the courthouse. But, you know, the cases are still moving at much the same time frame. Negatively, yes. I mean, the delays and duration are the story of the day for all the reasons we've been talking about. How much of that is actually from COVID, I think, is very much debatable. I think the larger factors are just a willingness and a determination by, you know, various defendants to dig in and do whatever is necessary to delay for as long as possible. You know, borrowing the old insurance playbook, of course, that they've been using for years. I think the sense in which COVID, the impact of COVID is still felt is that, you know, there were a lot of loans from 3 or 4 years ago where certain borrowers got hit really hard, where, you know, you might imagine a scenario where, all things being equal, a perfectly healthy law firm with a good business just had their cash flow frozen for 2 years, right? Well, if you were a lender to a firm like that and that were to have happened, you know, the effect of that is that, you know, before COVID, you had a great loan with an LTV of 14% or 15% or whatever. And now suddenly after COVID, you know, the LTV is, you know, 60%. And maybe that firm is going to have a hard time digging itself out of that hole as interest continues to accrue and compound. So I think there's probably some loans like that that are out there, and that can be directly traced to COVID.
Okay, great. For the audience, we're going to leave about 10 minutes for Q&A at the end. So if you have any questions, please feel free to submit those on the platform. So let's move a little bit, shift our attention to investment instruments. Joel, we'll stick with you on this one. Omni has made a number of recent moves involving secondary sales and private credit to improve their earnings and cash flow. What is your sense of how much pressure the industry is under to produce cash flow for its investors?
I think there is some pressure for sure, but more than pressure, I think it's a natural thing for, you know, self-interested managers to want to give their investors realizations so that they can raise more capital. Right. So, you know, even if no one had ever told me, boy, it would be nice to get money back at some point in the future, like that would obviously still be, you know, what I'm incentivized to do, because the sooner I can get realizations and get cash back, the sooner people can have confidence that, wow, this actually really works. And, you know, then they give you 2x the investment for the next vehicle. Right. So the pressure is, I think, part of it. But, you know, for a relatively new asset class like litigation finance, which is still, you know, in like middle innings, I think at most, you want realizations. You want to turn things over as quickly as you can and you want to get capital back.
Great. Joel, anything to add there?
Yeah, I think, you know, to a large extent what Joe said is what we're seeing, and we're seeing folks on the, you know, the origination funding side where they're basically saying similar things, right? If we could sell a participation in 20% of our portfolio, that validates to our existing investors the value. It gives us more capital to deploy. It creates some liquidity for them in the marketplace. You know, it does a lot of positive things out there. And if you sort of think about more mature specialty finance companies, you know, and apply that to litigation finance, right? They want the underlying capital to deploy dollars on their balance sheet. They want to be able to package and sell those portfolios in one way, shape, or form. And they want to be able to have, you know, call it, I'll say forward flows, although that doesn't really exist much in the overall sector, a little bit. And so you're seeing the firms becoming more mature, sort of thinking about how to both create liquidity, how to validate their thesis, and create both access to capital and, you know, sort of velocity of capital. And you also see folks that might be traditional corporations that are raising funds, and you're seeing funds that are looking at potentially buying businesses. Again, sort of I think it's a natural maturation in the sector.
Yeah, absolutely. So let's turn our attention a little bit to the insurance sector, which has been, you know, actively developing products and marketing products for the last couple of years in the market to either compete with or share risk with funders. What are your thoughts on the role of insurance in the litigation finance sector? Maybe we'll start with Jamie on this one and then turn it over to Joe. Jamie?
So in some cases, insurers haven't described themselves as being in competition with litigation funders, but we generally view them as broadly complementary to our business, and you know, haven't been in situations where we think our potential counterparties have elected not to transact with us and have instead pursued an insurance remedy independently. That isn't something that has happened ever, as far as I can recall, but certainly not with any frequent basis. You know, for the same reason that a company may use financing to cover the cost of legal fees, they may also use our capital to pay for an insurance premium to cover off some legal risk. So there's still an opportunity to lend, even if they would prefer to ultimately have an insurance solution to just a litigation funding one. So we use insurance regularly in our investments, specifically when we're funding litigation in loser pay regimes, but we also use it in some of our single case investing if we like a particular case a lot and want to build a concentrated position, but we want to manage the binary nature of the risk to protect our investment in downside scenarios. So even though we like insurance, I'd say it's not really a deciding factor in whether to make an investment for us in nearly any case. We think about its impact on the size of our investment or how we structure it, but it's not necessarily the dispositive factor on whether we proceed with something.
Right. Joe, how do you think about insurance?
Yeah, I think insurance is entirely complementary, and I love the fact, and I mentioned this earlier, actually, I love the fact that over the last, you know, even 18 months, there has been an increasing number of insurers coming into the space who are willing to draft and create, you know, bespoke policies, the effect of which is that we can be much more creative with our structuring, and I would say to get us into transactions that would otherwise not make sense. And I'll give you a real life example. I mean, you know, Kerberos would never, for example, invest in a single patent case exposure, right? It's just not our edge. It's not what we do. It's not our investment strategy. And similarly, we would not lend against a portfolio of patent cases. But if I can put an insurance policy in place, like a collateral protection insurance policy, that basically gives me a minimum return under the policy, and then if the patents hit, I can have an upside scenario that might be, you know, a 2x return or whatever it is. I mean, now all of a sudden that becomes a transaction that's very interesting to me. And fits our traditional investment strategy. And the reason why that is so important is not just because it's a nice trade, it's because that all of a sudden means that the opportunities that I'm evaluating in my pipeline are, you know, 4 or 5 times broader than they otherwise would be. This is critically important because I think one of the ways to execute in this asset class is to not have a buy box which is too rigid or too small, because if it is, then at any given time you have to ask yourself how many transactions are actually out there that fit this buy box. And if the answer is a finite number, the problem you have is either that you're under pressure to get cash out and you get into subpar opportunities, or there's cash drain. Neither of which is good. But if you can evaluate, and have your pick of the litter, so to speak, all kinds of different things, all of which are still fundamental to your core investment strategy, that's the best way to get risk-adjusted returns. And so the insurance is absolutely a part of that narrative for Kerberos. Great.
Chris, you mentioned regulatory in some of your opening comments. The International Legal Finance Association has come out against the idea of forced disclosure in all civil cases and federal quotes proposed in the Litigation Transparency Act of 2025. Is the issue of disclosure black and white or a little bit more nuanced? What would you say the industry has to say about, the commercial litigation finance industry has to say about disclosure?
Yeah, I mean, look, I think ultimately, like most things in life, it is somewhat nuanced. I think there are legitimate concerns, and to an extent, that have been raised in regards to certain areas of concern. They could be conflicts of interest, right? The things that courts might care about. But a lot of the proposals that we've seen so far have been really broad, right? And it's not something that it's kind of a one-size-fits-all solution or attempted solution to something that may not be a problem in commercial that might be a problem in consumer or mass tort, et cetera, right? I know that there is some middle ground, right? And I think this is a problem that will get resolved, hopefully rather soon. And I think that there are, we have some clients, and I think that there's a sentiment that some amount of disclosure would not be, completely unacceptable to funding companies, right? I think we've seen some attempts that have tried to get that middle ground. We've seen Judge Polster's proposal in the opioid cases. We've seen what's happening in New Jersey in district court, where we're really trying to focus on what is the core issue at hand, right? Is it conflict of interest? Is it making sure that the funder doesn't have control over the case? Those are things that I think people can agree we can disclose some of those things. We prefer to do it to the judge, right? We prefer not to have to do everything in front of the other side, or to engage in some sort of additional litigation over what can be conducted or what can be discoverable. But a lot of the proposals we've seen both in Congress and in some of the states are very broad, right? And I don't think it's going to be something that is amenable to a lot of funding companies, which is, I'm going to turn over my funding agreement. I'm going to tell you the details of how I'm funding, when I'm funding, what the milestones are, what our budget looks like, what our tranches look like. I don't think that it's going to be something that that happens. So I think we all need to kind of level set, right?
Great.
If I can just chime in on that issue, I really question the grounds for these proposals. I don't think that there are very many legitimate concerns, that certainly none that have been really articulated by the various parties proposing the rules and the groups that are supporting them. The fact is, the proposals that we're seeing are coming up in the context of having, for several years, having defendants make efforts to seek litigation funding agreements in discovery, and having courts reject those requests on the grounds that they're either irrelevant, the agreements are either irrelevant to the merits of the cases before them, and or the agreements might be privileged or work product on some level. The courts have repeatedly rejected these requests. Judges could at any time request the agreements and say they need to review them on an in-camera basis. So I find it peculiar that this entire sort of paradigm that now exists with these proposals strikes me as a solution in search of a problem. The fact is, if courts wanted to see these agreements or thought they were relevant, they could have done so, and they elected not to. And it seems as though there's now efforts to basically compel them to review the agreements, even though they've found almost universally that they're irrelevant to the underlying cases.
I think that's a great point. And I think there's been some certain subcommittees that have actually looked into the issue and found that when they've kind of reviewed their dockets and whether litigation funding has been involved, there really hasn't been a concern, right? And they haven't felt the need to put additional rules in place or additional regulations in place to monitor it. So I do agree that a lot of the concerns are overdone, but this kind of movement keeps coming, right? And so we'll see what where we can kind of strike a resolution.
Okay, great. In terms of what the ILFA is doing, do you feel like they're doing enough for the industry to counter some of the attacks that are coming from the U.S. Chamber of Commerce and others, or are they doing a good job of sort of holding their own? Chris, do you want to start us off there?
Yeah, I think they've in some of the state, it's not just been a concern or a focus on the federal, right? I think there also has been a focus from ILFA on trying to prevent some of the state court legislation from, kind of acting as a test case, so to speak, for additional litigation. So there's been, they've been involved in the big stuff, but also the little stuff, so it's not used against us, so to speak, right? So I think in that regard, it's good. I wonder, at what point is there some sort of proposal, right, as to if there's something that's amenable, is there something that we can all get behind, if that's what's needed in order to kind of stop these overbroad bills coming into both state legislatures and Congress. But I think overall the messaging has been clear, right, that this is not acceptable and is not addressing the issue you at least are claiming it to be. Okay,
great. We have about just under 10 minutes left. It doesn't look like we have any questions from the audience, so I'm just going to continue on with some questions. Maybe we'll shift our focus to Outlook going forward. And I'll get maybe Joe and Joel to comment on this. There's a recent soft launch of a new syndication platform called JurisTrade, which seeks to match investors with investment opportunities from law firms and other funders. What are your thoughts on this type of platform to increase the distribution of investment opportunities available to investors? Joe?
I think it's fantastic. I think this is exactly the kind of thing that is good for the asset class on the whole, and good for individual managers trying to generate realizations for all the reasons we talked about earlier, right? I mean, having a strong secondary market along perhaps with the insurance component, I mean, those are key things that you see in a maturing asset class. So this is another sign that the asset class on the whole continues to progress in a positive direction. But the more options there are, the more tools there are for liquidity, the better, because we can get capital back to LPs, everyone's happy, and then there's more strategy for the next vintage and so on and so forth.
Right, Joel, anything to add there?
I agree pretty much with what Joe said there. There's some other platforms that are out there that provide options for different fundings, and I think it's, again, you sort of think about other industries where these kinds of things are out there, right? There's business brokers that are selling businesses out there every day, and then there's Goldman Sachs that are selling businesses. So it creates options sort of along the stream from very small to some level in which it doesn't need to be curated. At some point in time, there are going to be bigger, more complex fundings or transactions that probably don't make sense on these platforms, but I think it's a good thing. I think it creates, as Joe said, it creates some options out there for folks looking for capital that are may not know where to go or how to get the funding, and I think it's overall it's a good thing.
Okay, great. Just before I turn it back over to John, maybe I'll finish off with one question. Obviously, in the U.S., there's a new sheriff in town. What do you think the implication of a Trump presidency will be on the litigation finance community, and whether he's generally good for the litigation finance community? Chris, do you want to field that one?
Yeah, it's interesting. I don't know just yet, right? I think in other asset classes we've looked at this from a regulatory perspective and thought, okay, well, I think this might be good for us, right? This could result in some less of regulatory oversight, and be kind of a favorable outcome. But I think one of the interesting things that has kind of taken over the dialogue, so to speak, and it's kind of a shift in the discourse over transparency and disclosure, has been money from overseas coming into cases and trying to understand who's funding these cases. That's kind of been where certain, like the Louisiana statute, the Litigation Transparency Act, has been one of the main bylines there, is trying to ensure there are no non-U.S. actors getting involved in litigation or swaying litigation, right? So this change, I don't know this is actually happening, right? I think that the general consensus is that this also is not a grave concern, at least from the litigation funding perspective. But could it provide an avenue for the administration getting involved, as it's been a concern in other sectors? It could. And so, I think that provides a little layer of uncertainty.
Any other comments there on the Trump administration and litigation finance?
I would point out that the same concerns about foreign investment motivated the Corporate Transparency Act, which the U.S. Chamber of Commerce opposed, and which the Trump administration has ultimately said it will not require compliance with. I think they basically have absolved various businesses that would have been subject to these disclosure requirements from having to actually comply with the burdensome requirements that were set forth in that law. So it is certainly conceivable that similar skepticism will be greeted by with the different disclosure rules to be applied to litigation funding.
Great. With that, I'll turn it back over to John. I think we may have a question or two from the audience.
Thanks so much, Ed. I do have a question here. This one not directed at anyone in particular, so feel free, whoever wants to take it. As litigation insurance market has taken some material claims and insurers reevaluate how best to participate in the space, how valuable is the perceptible difference in cases where damages being sought are fixed expenses, such as taxes paid in a refund case, versus more complex damages claims like IP, diminution in value, lost profits? So how valuable is the perceptible difference in cases where damages being sought are fixed expenses versus more complex damages claims? Any thoughts on that? Maybe no difference.
Oh.
Yeah.
Sorry, just to clarify, you said the question was how does underwriting work when the case has fixed damages versus complicated damages or more speculative types of damages?
Yeah, how would exactly?
Yeah, I mean, obviously, I mean, when we're underwriting commercial litigation, usually we write down sort of lost profits arguments when it comes to damages to zero. We just don't give a lot of credence to lost profits when in commercial litigation. We prefer to think of the investment in terms of sunk costs, generally speaking. Obviously, if there's fixed damages amounts that can exist in a variety of types of claims, that's ideal because they're certain. And if a party has sunk costs, those are obviously the most desirable kinds of damages from an underwriting perspective, as opposed to the more speculative categories that can exist when you're trying to assess like how much would a business have made but for the alleged breach of a contract or some other tort that could have existed. Ultimately, one kind of investment we see over and over again, or proposal for litigation funding, involves businesses that have failed and want to pursue a claim that allegedly is related to the failure of that business. And oftentimes, when you look at those proposals, the proposed amount of funding that they're looking for is worth more than the dissolved business or the whatever business remains, and that can be a problematic thing from an underwriting perspective, because obviously we'd rather just buy a company than part of a claim if the claim is the main asset and more valuable than the entire business.
All right, thank you, Jamie. That'll have to be it. We've reached the top of the hour, so we appreciate you all attending today's event. Thank you again for that. Of course, we want to wish a special thanks to our panelists and our moderator, Ed Truant, who did a fantastic job again. Thank you, Ed. and also to our esteemed panelists, Jamie Snyder, Joel Magerman, Chris Capitanelli, and Joe Ciprut. Thank you all for a fantastic job today. As a reminder, you will all receive a link to a recording of this event within the next day or so. Please stay tuned to your emails for that. We're also going to be convening our community for our next virtual town hall next month. So there'll be details to follow on that. We hope you join us again. And one more reminder, for details on becoming a Legal Funding Journal member, please visit us at www.legalfundingjournal.com. Thank you all. Take care again. Have a great rest of your day.